122, and you said you had no problem with 122H. So the very first hearing, he banned 122H throughout the whole entire proceedings. And that's against the Supreme Court rule, and when questioned on, he said, I can do whatever I want. I said, well, how do you overrule the Supreme Court? He said, well, I can do whatever I want in my courtroom, and if you don't like it, give a special action, but that's not really truly how it works. As we just saw here, 122 is the Supreme Court rule. So right off the jump, we were already, but I didn't want to go to a special action after the first hearing on my judge that's going to preside over my trial. So I let that one slide, and then, a couple back and forth, he was refusing to give the bond hearing right from April 4th when it was initially filed. I know that I referred to it from May 12th, but this started April 4th. The initial bond hearing was filed by Parvin on April 4th. As of April 28th, he was still doing research. Well, what research do you need to do on a rule of procedure that's black and white? So that had us, I don't want to say at odds, but we had a disagreement about the time frame of that, and he refused to rule on it. But then he had no problem ruling on a motion to dismiss the same day it was fully briefed. So he took 4.5 weeks to still do research on a motion for bond eligibility that's a procedural right, and he took 4 hours to rule on a motion to dismiss that has serious implications for both me and defendants across the state of Arizona. He didn't seem to need to do any research there, so that got my radar up, and I told him that I would be filing a Rule 10 because I didn't feel like he was being impartial, because it seemed like Ms. Stiles could file a recipe for an apple pie, and I could file a legally cognizable motion, and her motion would be granted. So at that point, I started to wonder. Okay, I said, Your Honor, I believe I'm going to file a Rule 10. That was at the April 21st hearing. However, I had no way of filing it because Parvin was still my counsel, and we had to have the Ferretti hearing to get him off as being my lawyer, so I could even file my own motion. So being in the jail, I had, my only remedy is to mail it. Well, I requested envelopes at the jail on April 17th. April 28th, they said they would get them to me. I still didn't receive them until May 9th, so I wasn't even able to file the original one. So that was leading up to that. The 10 days passed and I couldn't file it. So now moves us to the May 12th hearing. So at the May 12th hearing, I had moved on from the original Rule 10 because I thought, I just want to get this process moving. So at that hearing, we started going over these preliminary issues, and that's when the motion here began. But I want to pause right there for a second and jump ahead to the day I tried to file this motion. The May 12th hearing led to me wanting to file it. So May 19th, I come into court, before the judge is even on the bench, and I made it clear, this motion needs to be filed before the hearing starts for it to be, binding. I handed it to that gentleman who was in there, a different woman though, and let him know, hey, this needs to be filed before because I'm making, a request that needs to be done before the hearing. Once the hearing starts, it's too late, and it's got to be within 10 days. Everybody was aware of the spirit of what I was trying to do. I'm in custody. I'm at the jail. We had a hearing on May 12th. I go back on May 13th and write the motion. Had I put it in the mail that day, it still wouldn't have went through the mail system and got there prior to the hearing, because that was, just Monday to Friday. So if I would put it in the mail Tuesday night, say it goes out Wednesday, it still would not have been in the court's possession and filed before the hearing on Friday. So I thought, okay, I'll bring it to court, make it clear I want to file this before the judge comes out. They made copies, they had it ready, they set it on the desk, he comes out, and right then and there, I say, Your Honor, before we proceed, I want to do the Rule 10. So he pulls the book out. Oh, what is Rule 10? He looks it up, he said, oh, it has to be filed before the hearing. Oh, you're denied, you have to do, the hearing already started. I said, but Your Honor, the spirit, you have discretion. He has discretion to overrule the Supreme Court. He has discretion to, take 7 weeks or 4.5 weeks to rule on a bond motion. He can dismiss motions within the same day. So the judges do have discretion. That's a word that gets thrown a lot with judges, discretion. So everybody knew the spirit of what I was trying to do, file it before the hearing. Well, that established a back and forth where I said, well, Your Honor, I'm trying to do that. He said, I don't care. I said, well, what am I supposed to do? I'm in jail. How can I get it to you any sooner? And he said, and this is where I believe is just a cherry on the top of everything that he's done to me. He said, well, you're the one that chose to represent yourself. Well, that's right there. He's saying you're prejudiced because you're representing yourself. You're unable to do what you need to do because you're prejudiced by being your own attorney. And he's refusing to, the little bit of grace that would have took to say, in the spirit of what I was trying to do, that he has the discretion. Instead, he tried to force me to have the hearing for the bond, despite me trying to file this motion before the hearing so that he wasn't the one that ruled on it. He could have used his discretion. Instead, he chose to say, well, that's the consequence of being your own attorney. No, I shouldn't have any consequences. And he should have just said, you know what, you're trying to file this. It's no skin off my back. I'm going to accept it as it because you clearly did everything in your power in custody and in here today to get it on my desk before. But instead, he just, nope, I'm not doing it. And then I said, Your Honor, you're just blatantly violating the spirit of the thing. And he said, you're misbehaving, and he removed me from court. Now there again, right there, Rule 9.2. You can't just remove me from court and take me out and never. So either he needs to remove me from court and put me somewhere where I can still observe the hearing, or he needs to give me a chance to say to the security, hey, I'm willing to quote unquote behave and take me back in. That's literally written into Rule 9.2. You get removed. You get one chance to say, I'm going to behave if are you willing to go back in and behave? Yes, sir. Okay. If you go back in and don't behave, you're gone for good. Well, he didn't even give me that. They took me straight to the basement and one of the guards assaulted me. So, but that's handled in a different sense. So now back to the May 12th, because now we can see that he didn't even want me to file this for some reason. So the arguments I have are, the media was denied from the beginning, okay? And for no other reason than the victim, but it didn't comport with reality because the court is live streaming, but the people can't audio record. That doesn't add up. And his excuse that the victim, well, how is the victim harmed any more by somebody sitting back there with their phone recording than, audio only, than with the court broadcasting it and somebody recording that? That doesn't comport with reality. So that right there, because I have a right to a public trial, media coverage. We've touched on that in this little hearing that we just had. Your interpretation of the fairness of the media being allowed in the building versus being able to video. You reached the compromise of 122H. That's not something that you can just take away. Even your admin order says, 122. We follow it strictly. We're going by 122. 122H says you can. 122C and all that means that you can have a hearing and use your discretion. So that's what I felt he should have did. At no point did he use his discretion. He just banned it throughout the whole case, which that takes away each person's ability to argue for themselves. But the real thing that matters is this bail eligibility hearing, where you file a motion under the rule and you're supposed to get a hearing within 7 days. He took it to. So the motion gets filed April 4th. As of April 21st, he was still doing research to decide if he was going to have a hearing, No, that's not the rule. That's not the case law. The case law is clear about this, that it's a matter of right. You file the motion under Rule 7. When there's a change of court, the court was changed. The de novo standard is re-examine means renew. The Court of Appeals is defined what they mean by re-examine. That means a de novo review. So the only way you can de novo review somebody who's not eligible for bail as a matter of right is to have another evidentiary hearing, because you're
Mr. Rhodes, just so I'm sure, which rule are you referring to?
7.4C.
Okay.
Yeah. 7.4C. It says that if on a motion, the court on its own, sua sponte type thing, or on motion, can re-examine bail eligibility. Well, the plain meaning of bail eligibility, everybody's eligible for bail as a matter of right, except people who are not eligible have been held not eligible for bail as a matter of right under the 7.2, presumption, what is it called? You know what I'm trying to say, where they find proof evident or whatever, you know what I mean? At the initial hearing, they find that, and then you still got to be indicted though. So that you have the initial one, you still got to get indicted in the justice court, it gets brought over to the superior court, and you can move to re-examine bail eligibility. Well, the plain meaning of bail eligibility is you're not eligible, or you're eligible as a matter of right. Everybody's eligible except this limited class of people that get found proof evidence. So right there, he interpreted he said, well, that's not how I interpret it. Well, there's no other way to interpret it when the Court of Appeals has made it clear that the word re-examine in that rule means de novo review. Well, de novo means you throw everything that happened away and you start over. To start over for somebody who's not eligible for bail as a matter of right is to have another evidentiary hearing. It's right in the case law. And I realize we're not arguing that motion right now. So I don't, which I've been trying to do for 7 weeks now. I've been trying to argue this bail motion, but I'm being held with no bail and denied the chance to argue why I should get bail. The state should be forced, because the things they held me for, one of them didn't even get indicted it got indicted as a misdemeanor. So their whole you're being held for these felonies. Well, one of them is a misdemeanor now. So I should get a chance to re-examine bail eligibility, the plain meaning of the word, and then the case law says two reasons you can do that: transfer to new court or new material facts. I was transferred to a new court. I applied for a bail eligibility hearing. It's a re-examination. Re-examine means de novo. Well, we got Metcalf going, well, I don't really feel comfortable looking over Judge Miller's shoulder. Well, no, that literally by rule of procedure and controlling case law, that's exactly what you need to do. You need to take what Judge Miller did and set it over here, pretend it never happened, and start from scratch. De novo, review anew, start over, de novo review, they start over. That's what that means. So he's letting the state file, like I said, a recipe for apple pie, and saying, oh, well, your motion's denied because the recipe for apple pie says you don't get another hearing for bail. And that's right there. That's intentional disregard for the rules. That's not being impartial. That's being biased. That's being prejudiced against me. He's not taking my argument serious because I'm pro se. There's no other defense attorney in this court, no other judge in this court, no other defendant in the state of Arizona has to wait 7 weeks for a bail reexamination. That's a procedural right. It's a procedural right. It's not even something the state can argue against when it's a procedural right. You have the right to this re-examination. It's not, oh, well, we'll decide if you have the right to, we can file a motion and you can ask. No. You file the motion, you get the hearing. It's that simple. That's one thing. Now, the denial of the speedy trial, when he was setting the trial, I said, Your Honor, you have to set the trial in enough time to have sentencing before the speedy trial runs out. He says, no, you don't. No, you don't. That's not how it works.
And what rule is that?
That's case law. It's in my motion. It's case law. It's in my motion right here. Speedy trial. Right here. That's State v. Bartlett, 179, Arizona, 109, 876, page 2D at 114. Court of Appeals, 1993.
Thank you.
In light of the foregoing authorities, we hold that the guarantees to speedy trial found in the Sixth Amendment of the U.S. Constitution and Article 2, Section 24 of the Arizona Constitution apply through sentencing. So him saying, no it don't, and if you don't like it, file a motion. No, I don't need to file a motion because it's literally been it's been affirmed since 1993 that in light of the foregoing authorities, the guarantee to speedy trial applies through sentencing. So when I say, Your Honor, you're not leaving enough time from the trial to sentencing, to do the sentencing, the whole sentencing, you gotta wait, you gotta go through the pre-sentence, all that, before my speedy trial runs out, he says, oh, well, sentencing doesn't apply. And when I say, yes, it does, it's case law, he says, well, if you don't like it, file a motion. No, I don't need to file a motion to uphold my constitutional rights. That's not how this works. It's not, well, you have this constitutional right, and I'm going to use my discretion today to decide if you have that constitutional right. And if you don't like me taking away your constitutional right, you can file a motion or a special action and make yourself sit in jail for another however many months with no bond while the case is stayed, so we can decide that you do have the constitutional right to a speedy trial. That's not how this works. And he wouldn't do that to any other attorney. He did it because I'm pro se. And so that's a big thing when you're taking away a constitutional right. And we sit here and talk about, you have all these rights and you're innocent until you're proven guilty and you have this due process. Well, I don't have due process because he's telling me if you want due process, you have to file a motion to get due process. No, I have due process when I wake up in the morning. Everybody in this room does. Every single case that comes before you, ma'am, that applies to, it's a constitutional thing. It's not judge's discretion to decide if today we're going to do the speedy trial and we're going to apply it through sentencing or not. No, it's constitutional right. He denied me the constitutional right and told me to file a motion. Moving on to the jury questionnaire. He allowed the state to argue that the state would be prejudiced, which the state doesn't have a right to a fair trial. Only I do. The state does not have a right. That's in case law, up and down. The state has the right, the defendant has a right to a fair trial. The Sixth Amendment, all the rules of procedure guarantee the defendant a right to a fair trial. They don't guarantee they don't guarantee the state to a right to a fair trial. And how can the state be prejudiced by the truth coming out? The state should, if the state if their charges are based on the proper factual basis, and they're not in bad faith, and they're doing everything by the book, how could somebody talking about their case prejudice the state? No. So they were worried that if a jury questionnaire went out, people would go to my YouTube channel and see what they're doing to me. Well, how's that any different than somebody gets charged with murder and KGUN 9 does a story about them being charged with murder, and they interview the victim and the witnesses, and the state gives a little,
Mr. Mayor, you got about 3 minutes.
Right,
I gave you a couple extra.
That's great, I appreciate it. The state has no problem when a murder victim, murder suspect is on the news. They don't claim they're being prejudiced that a city of 1 million people, the jury pool is going to be tainted. What are they saying that? A couple hundred people are going to watch my channel, and then they can't, out of 1 million people, they can't find enough people to have a jury? So the state does not have a right to a fair trial. I do. And if I want my story out there, that's my right to have my story out there. And if a couple people read it and check my channel, that doesn't disqualify every single potential juror in a city of 1 million. Now, moving on to the retaliation thing, as you saw in the transcript, he said, word for word, I said, he said, we're going to have the hearing, I have a trial next week, then how are we going to have it within 7 days? We're going to come back on. And I said, no, you're going to follow the law, you're going to get off this case. He says, I don't like threats. It's not helping your case. How is that a threat? What threat am I saying? You're going to follow the law or get off this case. I have the right to file a motion for a change of judge. How is that a threat? Threatening to what? Follow the rules of procedure? And I said, was that a threat? He said, you're threatening me. And I said, you're threatening me now. And he said, no, you're threatening me. You're telling me if I don't do what you want. I said, no, I'm telling you, you need to follow the law. And he says, okay, and I need to read what it is. And I said, you don't need the law, right? So how is me saying, quote unquote, threatening? No, I was implying that I'm going to file a Rule 10 motion on him. He's saying it's not helping your case. So me telling him he's going to follow the law or get off the case, it's not helping my case, that is retaliation, flat out. Now, I realize there was a little space between me saying, you're going to get a lot of complaints, and then, it's not helping your case. But either way, the spirit of his statement is that he's somehow, by me implying that that he's not following the law, I believe he's not following the law, and that I'm going to file a Rule 10 or whatever, exercise my rights to get him off this case. He's saying it's not helping my case. Well, there's no other way to read that and hear that, and he's going to hold that against me. He's going to hold me saying you're going to follow the law or get off the case against me. Why would it? Because if it's not helping, that means it's hurting. So why would that hurt my case? How does me saying that you need to follow the law or get off the case hurt my case? He would never say that to an attorney. He said that because I'm pro se, and it's clearly a threat. He's calling me threatening. He's using the word threat, which is a legal term, of a Rule 10, as something that is going to hurt my case. Well, how's it going to hurt my case? That's what I want to know. And he just ended the hearing. So I don't feel comfortable with a judge who's saying that me saying I'm demanding what I'm owed by these rules is hurting my case. So that should, because I know you said 3 minutes, right?
Yeah, and you just landed it, perfect. All right, so, Ms. Townsend, you have 15 minutes from the order to recall.
Your Honor, Mr. Myers has not shown anything suggesting that Judge Metcalf has an interest or prejudice that would prevent a fair and impartial hearing or trial in this case. What he's gone through is just his disagreement with the judge's rulings, which is not grounds for 10-1 and for a change of judge for cause. So when he's talking about the live streaming, so that issue that he's brought up, this has been an ongoing issue in the court hearings where we have a lot of disruption before court even gets started, where we've had issues with the audio and the video streaming. As I said, even people who are going to do the personal audio, we have people that were using their phones and turning them in such a way to try to film. This is a harassment case against this victim has been harassed on social media. The people who have been coming to court are all connected with social media, so there is a concern about the victim suffering additional harassment throughout the process, which she has had additional harassment that's been done to her throughout the process with people, with the calling and things happening in the case. So the court, in just ordering the live stream and not having people audio record, is because people weren't complying with court staff. There was no way to monitor to make sure they were only audio recording. So the court made sure it was available to the public where they could record it from as they wanted with the audio stream, but then they weren't able to then film the victim or film anything they weren't supposed to be filming. In talking about the no bond hearing, there was a no bond hearing held in this case. It actually took place over 2 days. There was testimony given at the no bond hearing. There were exhibits presented at the no bond hearing. So a full no bond hearing did happen. So Mr. Myers is referencing 7.4 when it transfers, but he's not indicated any change in circumstances warranting another review. I think he's under the false impression that this court is holding 2 no bond hearings every time somebody's held without bond, but that's not the case. It's extremely rare that after a first no bond hearing is held, that a second one is held, because there's usually nothing new that would be presented at it.
I'm not aware of any, are you, just because I obviously
I haven't, I'm sorry.
I just wondered if you were aware of any where a no bond, had a second no bond hearing. I'm not aware of any, but
No,
okay.
no, I cannot think of a single case where somebody has had a second no bond hearing. And in this case, he was indicted on the 2 felonies for which he was held without bond. So those 2 felonies are still in place and have been the entire time. So I think he just has this, he sees it in the rule, but in Rule 7.4, it's not mandatory, it's not shall, it's may. And that's very different. And I think if there were some material circumstances that would warrant a no bond hearing, that could potentially happen, but there are none in this case. And when he's referencing the time frame, when he was with, where Mr. Carbon was representing him, Mr. Carbon had filed a motion, we had the argument on it, and then Mr. Carbon contacted the court and asked the court to withdraw it from consideration. So then the court stopped considering it until then Mr. Myers filed his own. But then the court wanted time to be able to review Mr. Myers' pleading and set it for a separate hearing. And so that's the time frame is actually very short from when the court was setting it for when Mr. Myers had actually filed his motion. Regarding speedy trial, I think Mr. Myers just doesn't fully understand there's this the time limit for speedy trial to get the case to trial, but then there's a whole separate time frame for sentencing that has its own speedy trial per se under 26.3, where it has a separate time where it's mandatory when the sentencing. And I think Mr. Myers just may not understand there's actually 2 separate time frames for that. But regardless, the date for the trial in this case is set well within speedy trial time, as I noted in the motion. And so there's nothing in this case that's indicating that Judge Metcalf has any bias or prejudice. It just seems purely that these are disagreements with the judge's rulings. And And so, for those reasons, I don't think he has met his standard. It is his burden to show that this judge should be removed for cause, and he has not given anything other than disagreements with his ruling to support his argument, and so we would ask for it to be denied.
Ms. Stiles, were you present on the May 12th, and I believe Mr. Meyer said May 19th
Call me
hearings?
when it's over. I left my
He
stuff in your car.
said that he
Leave my keys. No.
filed
Yeah, I
wrote the
can go do it
motion
right
right
now.
after the May 12th hearing, which corresponds with the transcript. And then on the May 19th hearing is when he provided the motion. Were you present at those?
Yes.
Okay. He indicates that he felt that, and by he, I should make that more specific so the record's clear. Mr. Meyer seemed to indicate that Judge Metcalf was denying his motions or not setting his motions or delaying setting his motions. He kind of used a variety of things because he was self-represented versus if he were represented. Did you notice anything in Judge Metcalf's rulings that appeared to be treating Mr. Myers differently because he was self-represented versus being represented by an attorney? Or in his actions in court, doesn't even need to be a ruling.
No, Your Honor, I think with reference to the filings in court, Mr. Myers does have advisory counsel, so he has the ability to get documents to his advisory counsel in advance of court, where his advisory counsel can assist him with filing things prior to coming to court. And so I don't think it was an issue with the judge having an issue that Mr. Myers is representing himself, but he does have a mechanism through his advisory counsel in which to file things without filing them and handing them to the clerk in court. And in court, there's some confusion about what they were filing. One of the documents Mr. Myers had filed prior to that, actually, it was his motion for the redetermination on the no bond hearing. Mr. Myers, when he gave it in court, it never actually got filed. And so the next hearing, I had to actually notify the court that it actually wasn't filed and it wasn't in agave because of that problem. And so I think what the judge is indicating is he has advisory counsel to assist him with that, he's just not utilizing it.
Okay, thank you. I wanted to verify your. Mr. Myers, Ms. Stiles did not use all of her time, so if you want a little extra, I can give you 10 minutes for any rebuttal comments you'd like to make.
Thank you. The first thing is advisory counsel is not my secretary, he's not my paralegal, he's not my law clerk, he's advisor. When I need advice, I ask for advice. There's nothing in the procedure, like the agreement of advisory counsel where I call him up and I say, I need to file this motion, can you pick it up at the jail and go file it? He is not my secretary. And the state keeps trying to pigeonhole my advisory counsel as my secretary, my law clerk, and my runner for like they use runners to bring motions over from the building to the court. That's not his purpose. He's there to give me legal advice. He's not there to file motions on my behalf. The motions I'm required to file the motions. I write the motions, I file the motions. He's not my secretary. And she's been saying this throughout the whole trial, how, well, he's getting his due process at the jail. I know he has no way of defending himself at the jail, but he has this advisory counsel who can do all this for him. No, they can't. They have other cases. They have other things to do. They don't have time to sit around and take hours out of their day to come run my errands or file my motions. And furthermore, how would I get it to him unless they come to the jail? So what do? Call up Resnick and demand that he comes to the jail and pick this motion up and take it to court and file it? He's not under any obligation in his agreement as my advisory counsel to come to the jail and pick up motions and take them to court and file them. He's there. His obligations are to provide me with sound legal advice. They got to get off this. And she filed a notice, and I don't even know why you asked her opinion really, because you didn't ask my opinion.
I was trying to understand. I understood your opinion to be that you considered it and those things, and I just wondered if she saw something different in the way he was treating you than he did people with counsel. That's all.
I mean, but that's her opinion. What do you think she did?
And that's all. Honestly, I didn't know what her opinion was, so that's why I asked.
Well, her opinion is anything against me is against me. I mean, now I want to really talk about this bail thing. I know you said you never seen it. Well, that's shocking. For 14 years on the bench, you haven't seen this when it's clearly in the rule and there's a bunch of case law and the motion contains case law, and their response was a recipe for apple pie, which talked about a different court, and they literally changed the wording of the rules in their reply to gaslight the court into not taking my motion seriously. Why would it say that if you're transferred to a court, you can get a new hearing? It doesn't say, and there's new facts. It says, if transferred to a new court, comma, now we all had to pass English in here to get our college degrees. Well, a comma is not an and, okay? If it said, transferred to a new court and new material facts, it wouldn't have a comma, it would have the word and. It says, if transferred to a new court, comma, if new material facts, or something about that applies to the conditions of release, which don't apply, they can't pay the money or something like that, which doesn't apply. There's plenty of case law that says you get it. Why would you get re-examined bail eligibility? Under what pretext could you re-examine bail eligibility if there wasn't another hearing?
City
The
Hall.
whole point of the wording is, if it's transferred to a new court, you can re-examine bail eligibility. So if you've never seen it, I don't know how, because you clearly have the right to file a motion to re-examine bail eligibility, and then when you look at the case law, how is that interpreted? It's a de novo review. Well, a de novo review for somebody that is not held eligible is a new evidentiary hearing, and there's case law on that, and she took my case law in her motion, and she responded, and she made up her own version of what it said, and she failed to even address the merits of the most binding statement in the Rule 7 motion, which was the Mendez versus Robertson case, where it clearly says 2 instances is or, transferred or new facts. She completely ignored that in her motion. I mean, her motion, we're not even hearing on that right now, but it's literally a recipe for apple pie. It's not a response to what I wrote. And absolutely, positively, you can file a motion and have somebody who's held without bail, because that's the whole point of having a re-examined eligibility. There's only one class of defendants where we re-examined eligibility. Every single defendant is eligible for bail as a matter of right, except a very limited group that are held without bail because of the class of their crime. So if you're going to re-examine bail eligibility, well, everybody other than those people are already eligible. So clearly, it's intending for you to re-examine people who are not held eligible. And the case law supports that, and the case law says that when you examine bail eligibility, it has to, the only way you get due process when the state's trying to hold you without bail is with an evidentiary hearing. She turned that into something completely different in her response, and the court just buys right into this. I'm not saying you, ma'am, but I mean, you just asked her if you've never seen it. Well, that's scary. I'm scared now. I'm really scared because the whole world knows that you're entitled to a bail evidentiary, a re-examine hearing, if it's transferred to another court. The rules allow for substantive review whenever the person's case is transferred to a different court. Rule 7.4 shall be held on the record as soon as possible. Right to due process. It's all in the case law. How is it not a rule that you're entitled as a matter of right for? I don't understand what I'm reading. We all passed English, like I said. She trains a Turk, may, right? So may. Well, ma'am, people could ask. Ma'am, you ask your teacher, may I go to the bathroom? Yes, you may. Or you ask somebody, are you going to the beach today? Well, I may or may not. There's absolutely multiple definitions of the word may, okay? There's when it says the court may, yeah, well, I filed the motion, can we have my hearing? Yes, we may have your hearing. It's not, well, we may or may not have your hearing. This is not English, this is law. It's not surpluses, it's not, an English competition test, it's comma. And she keeps saying and. No, if they wanted an and there, if it required a change of court and new facts, they would not have a comma there, they would have the word and. So then anybody reading that at a 6th grade reading level, which the rules are, or maybe 8th grade, they would read, okay, so the conditions of getting a new bond hearing are transfer to a new court and material facts. If they wanted it to say that, it would say that. And Metcalf already got called out in the appeals court for not understanding the plain language of the rules. It literally says when the court is re-examine means de novo. How could you have any other, how could we examine, let's give her argument some food for thought, which we shouldn't even do, but let's do it. Well, how could you have re-examination of bail without another hearing? The rule also says conditions of release. Well, I'm not asking to review my conditions of release because I don't have any conditions of release because I've been held not eligible for bail. That means we're gonna take the part of the rule that says re-examine bail eligibility and we're gonna re-examine it. So we're gonna have a new hearing because if you don't have the new hearing, you didn't give me a de novo review. So I don't understand what I'm reading that they're not, I mean, I know that the whole point, the trick of law is, my wife's an attorney, who's a law clerk for this court. So I understand, she tells me all the time, lawyers get paid to lie, right? Lawyers get paid to twist your words, lawyers get paid to write stuff on paper that doesn't make sense, that just sounds good.
You've gone about, well, I had 10:18 to be stopped, so about 11 minutes, but I'll give you another minute.
Oh,
to wrap up.
okay, I'm just
I want to give you.
This isn't the bail eligibility hearing. I just want a fair chance to, because if the state has no problem meeting their burden, what are they so scared of? Why wouldn't they just come in there and show the same evidence and rubber stamp it? It's because I had a counsel, I wanted to continue it, I wanted to represent myself at the bail eligibility hearing, the counsel asked less than 5 questions, I didn't get to testify, we didn't present any of the evidence I wanted to present, so they know that if I get this bail eligibility hearing, that I'm gonna handle it differently than the first one, and that I'm gonna get bail because there is no way for them to meet the burden of proof evident if I'm asking the questions. They just, and they had Tracy Miller, who was working at the prosecutor's office a few months before this, and is friends with them at the U of A. I mean, I know you worked at the prosecutor, but you worked under Barbara Wall, who would never bring these charges. And so I know you have a different, I'm not lumping you into that same category as Tracy Miller. And I also tried to get rid of Tracy Miller under Rule 10, but Harvin wouldn't file the motion because he's got to kiss everybody's butt around here because he's got to, try to run for judge. I don't. But, this is about transferring the judge. I don't think me and Metcalf need to be in the same, I'm not comfortable. I mean, it's not just about being comfortable. I understand there has to be facts. I filed the affidavit. The judge saying it's not going to helping you means it's going to be hurting you. I mean, he removed me from court and I said, I'll behave. He said, nope, doesn't matter, remove him. There's no other way. He's just blatantly being impartial towards me. He has inherent bias towards a pro se defendant when he says, oh, that's what you get for being pro se.
Okay, I need you to.
You're good.
You're okay, all right.
Yeah.
Thank you, Mr. Meyer. I'm looking at, Rule 10.1, which reads, a party is entitled to a change of judge if the party shows that the assigned judge's interest or prejudice would prevent a fair and impartial hearing and trial. There were multiple, thinking of the best word to use, I guess, multiple allegations that Mr. Myers used in his motion to show, or from his view, that Judge Metcalf had an interest or prejudice that would prevent a fair trial. As I mentioned, I did see the state's response this morning. I'm going to deny the motion to strike the response. However, I'm not going to consider the written response, but I am going to allow it to be in the file. But I have the first allegation by Mr. Myers was the denial of media coverage, and while you can agree or disagree with that ruling, I don't believe the denial of it shows an interest or prejudice that would prevent a fair or impartial hearing. The second one was a violation of the admin order. Again, I don't find that shows an interest or interest or prejudice that would prevent a fair trial. With regard to the speedy trial, under Rule 8, an individual who's in custody, such as Mr. Myers, must have a trial within 150 days. And based upon the calculations done by my office, he's well within the speedy trial by having a trial on July 22nd. Additionally, I think he may even be, if we're convicted at trial and sentenced within the 30 days, still within the speedy trial, because I calculate it to be sometime in the 1st of September. But even, even if you're right, sir, and it's August 11th, you may be a couple of days after, but under Rule 26.3, that's where the sentencing has a speedy component in it, and that is 30 days from the time of conviction. So I disagree with Mr. Myers, and my legal basis, in case he wants to appeal this, is that the rules require 150 days under Rule 8 for trial, and then the Rule 26.3 requires 30 days for sentencing. I don't believe that 30 days, based on my review of the rules and the law, is incorporated within that 150, but would be an extension of that. And based upon that, I do not find it is a violation of speedy trial, based on that legal analysis. With regard to denial of the bail on re-exam, again, looking at Rule 7.4C, it states, generally on motion or on its own, a court may re-examine bail eligibility or condition of release. And then there's some other information provided with that. And the last sentence is the court may hold oral argument or an evidentiary hearing. While I agree that Mr. Myers has a right to file a motion to reevaluate his conditions of release, based upon the rule, the court may or may not hear that motion. Again, I see no bias or prejudice if the court chooses not to hear a motion on review of release conditions, because that's within the court's discretion under Rule 7.4C1. With regard to the denial of a jury questionnaire, there is no right to a jury questionnaire. There's a right to a fair trial. That can be done through voir dire questions. It doesn't need to be a questionnaire sent to the jury. There's been no information or evidence presented that having a jury questionnaire gets you any more or less bias prevention, and there's nothing in the court ruling that would show a bias or prejudice or interest of Judge Metcalf for denying a jury questionnaire. And just on an aside, of the trials we do hear, a very small percentage have jury questionnaires. Threat of retaliation was the last one. With regard to the information provided in Mr. Myers' motion, it had a quote, "Don't threaten the court, it will not be good for you." That's not exactly what was said. Also in Mr. Myers' motion, he indicated that this had to do with the violation of judicial conduct, judicial code of conduct that Mr. Myers said. In referring to page 5 of the transcript that the court ordered, Mr. Myers said, and this is on line 16, that's a violation of the code of judicial conduct. The court's response was, all right, you can file a complaint then. Mr. Myers then said, you're going to get a lot of them. The court said, all right. I don't find that to be at all argumentative or a threat to against Mr. Myers if he chose to file a judicial code of conduct complaint, clearly within his right, and clearly the court said, go ahead and file one. On the page 7, the court does says, I don't like threats, it's not helping your case. And there is a discussion with regard to that, but again, there's no bias or prejudice shown right within that transcript or within the argument that Mr. Myers has made. So in considering all of the arguments and the law as the court views it, which I recognize is different than Mr. Myers, the court finds that there is no prejudice or interest that would prevent a fair trial shown on behalf of Judge Metcalf, and I will deny the 10.1. With regard to then, just also on the record, the court received a notice, I believe it came from Ms. Stiles' office, that procedurally today she had met with Mr. Myers before, and there may be a possible change of plea. And I wanted to address a couple issues with regard to that. One, whether there is a change of plea, because obviously that's the first question. Two, if there is a change of plea, I can certainly take that without issue, taking a plea, but then the case would go back to Judge Metcalf for sentencing. And just for the record, even if this court were to keep the case for sentencing based upon my current position, I don't have a caseload, so it would go back to Judge Metcalf if there were a violation of probation or conditions or anything. I don't know what the plea is. That's just a guess given the charges and my experience.
that it would be probation available. So, Mr. Resnick, Mr. Myers, I didn't know if you caught all that.
We're listening.
Okay, good. Absolutely.
Hey, I know. I just remembered. It's a Carl's Jr. I wrote with him. You remember that?
Just give me a call. I'm gonna go meet him right now. And then go drop
It's
it off.
almost done. Just wait.
What do you say? He's waiting.
Well, Mr. Resnick was
about
saying, I had provided to me the rule 122 and then the information provided by Mr. Kelly that's titled Motion to Affirm First Amendment Right. I'm gonna order that these be filed. These were all consolidated in lowercase number, is that correct, these files? Were they physically consolidated or just consolidated for purposes of trial?
It's just for trial, so they're still separate.
I'm gonna have them filed in the 2025-1060, just so it's clear, but I'll note that they're in both locations, or consider them in both matters, for the record. Just for any appellate purposes that they may have. Okay, no, that's okay. And how did you all wanna proceed? Mr. Myers,
With,
do you want to do the plea, do you not wanna do
well, I
the
had some
plea?
questions about the plea itself, because the one I got, it seems like they've been going back and forth,
That happens.
figure that out, because it didn't look like anybody else is in jail.
Do you want me to?
Your Honor, I have a copy of the court.
Okay.
Copy.
Yeah, if you could hand that to me. Mr. Myers, Ms. Stiles is gonna hand me a copy just so I can follow what your concerns are, and if I can address them, great. If I can't, it's not a problem. You do not have to enter this plea today. If I do take a plea, I need to know you're doing it knowingly, intelligently, and voluntary, so I don't wanna do it if you feel any threats. But, I'm just looking at it so I can understand your questions.
Yeah, the first one didn't have that, oh, go ahead.
And Your Honor, if the plea is accepted, the victim would just like to be heard. And then, I know Mr. Myers was referencing the 85% language that was missing from the copy of the plea, so I got that inserted. We didn't realize that was missing.
Okay.
I did inform when Mr. Resnick asked me a question that obviously would still be the law regardless of that paragraph being in there, but to make sure it's clear to everybody, we put it in there.
Okay.
Judge, and the other issue that Mr. Myers had was the interplay between the operative terms of the plea and Rule 7.7, ARS 13-703. I spoke briefly with Ms. Stiles about that when Mr. Myers raised it to me. I guess the issue is consolidation, because once they're consolidated for trial, the judge is obliged to sentence the defendant as a Category 1 offender, which would not make him probation available. And I guess the state could waive 703, and the court could agree to waive 703 for purposes of the plea. But I think the issue was, once they're consolidated, that being consolidated for trial, occurring on some occasions, consolidated for trial. I wasn't advisory counsel at that point, so I'm not entirely sure procedurally whether or not they were or not. And so that was Mr. Myers' concern, and I think he's right to raise it. I imagine there's a way to fix that, but.
Well, it looks like under the plea, I'm just looking at the top of page 2, because he's probation available on both.
Well, I mean, I don't.
I'll just get it later.
Maybe I'm misunderstanding.
That's
What
the
is
paper
it?
says, but
It's
that's not
just
the
a
law
battery
says.
in my charger.
So Your Honor, for trial purposes, only for
Thing I
trial
had over
purposes,
my-
they consolidated.
I got several.
Under the plea agreement, they're not
I just need the
consolidated
charger.
under the plea.
Oh.
And under the plea agreement, he is probation available in both
It's all right.
matters. And so
This will be done shortly.
that would
It's
be
just
very
really
clear, it's
everywhere.
clear in the plea agreement,
it's
and
coming.
make it very clear
I'll get it
today.
All right.
And so that he would not be facing anything under 13-703 for the consolidation.
So, Mr. Myers, my experience with plea agreements is they often say things that, if you got right down to the law, would make them not probation available. My example is possession of certain drugs for sale. You can possess a certain drug for sale, and if it's a certain amount, it's probation available, assuming you have no priors and all that, right? So it's a probation available. You get over what they call over the threshold, 9 grams in some cases, certain number of pills and other things. You get over that threshold, it becomes not probation available. So a plea offer that the state may offer in a case like that is, you're facing prison, and this is obviously not you, but this is just my example. The person is facing prison for possession of methamphetamine for sale, and they've alleged over the threshold. They plead them to the same charge, possession of methamphetamine for sale, but they don't go with the threshold. So now they're probation available. So they're making, and that one might be a bad example, but they're making, because it's meth that I chose, they're making it probation available, even though with the amount, it would be no probation. So the same thing is true on certain cases. For example, somebody with a prior felony conviction may not be probation available. But if they drop that allegation, they're probation available. By doing this plea, saying that on the top of page 2, that the probation available term for the 5 is 3 years and for the 6 is 3 years, it is a probation available plea as I read it. So probation is available. Yes, it is available on both. If it was not available, the way the plea agreements that I've always seen will say something like, as to count 1, probation is not available. As to count 2, probation is available and it can be for 3 years. Or as to CR this, probation is not available, and as to CR this, probation is. The way this is written, it is probation available on both, and it is a contract on both. Probation is available to you. So again, that's a court's discretion. So it's not 100%, but it is available. And as are the sentencing ranges.
Right, because I know the allegation of like the priors and all that, I just wasn't sure because of I wasn't sure if it was overlooked or, because these things get a lot of copy and paste or.
No, it's a very good question. So I always look at, do the charges match? Okay, so you got a 5 and a 6 and probation periods that match with those. Are they probation available or not? And under the probation they are. The next really, it's all important, but the next really important thing to me is the special terms, because that's where unique things can be written into a plea that aren't standard. Because a lot of this other stuff is standard for everybody, regardless of what you're entering. But the special terms are not. And that has that the parties agree at the time of sentencing, and it cites a statute, the defendant shall be served with an injunction that prohibits the defendant from contacting the victim. The injunction does not expire and is valid for the defendant's natural life unless dismissal is granted pursuant to, and again, it cites that statute. So that's an important, unique feature of this plea that would be different than others.
Can I have one moment?
Absolutely.
I was wondering about, in Rule 7,
Yeah, go ahead.
in Rule 7 to C, you can be released if there's a likelihood, well, the rule reads, you can't be released if there's a reasonable probability of prison.
Right.
And so to me, this whole case is about videos on YouTube, right? So I'm already sitting in jail and the videos are still up. So I'm charged with a crime. I'm sitting in jail and the alleged crime is still happening. And then I'm going to plead guilty to a crime, sit in jail, convicted of a crime, and the crime's still happening, I feel like that makes a mockery of this whole court. In the sense that, you know, it must not be a crime, because I know in your 14 years as a prosecutor, you never agreed to a plea bargain where if you take this plea, you can keep committing the crime. That's never been a condition of the plea bargain, where you said, you know what, you can be charged for this crime, you can be convicted of this crime, but go ahead and keep committing it. Don't worry about it, it's no big deal.
I think I understand what you're saying. I think you can't keep committing the
Well,
crime.
the crime is the video that's on my YouTube channel,
Right.
and only I can take it down.
Yes.
So I'll be sitting in prison, and the video will still be up, and the crime will still be happening. That's doesn't comport with reality.
Well, they're charging with regard to specific dates, so that's one thing. All charges have a specific date and time,
Well,
so.
one is count one, well, they're calling it count 14, is the
Right.
period of time involving multiple videos. So I'm sitting in jail and people are watching the videos as we speak.
Well,
So-
I think that if the state wanted to file another charge with today's date, perhaps they could do that, and that would be a whole nother legal argument. If you're asking me whether that could happen.
Well, no, I'm saying that, you know, what are we really doing here if the crime is the videos and they're not even worried about the videos coming down?
Well, sir, that's not a decision for me today.
Well, you
Me
can release me, that's what I mean.
Oh, under 7.2, so when there's a change in circumstances, and I think the fact that you have gone from what is considered a no bond because you have something on release and an allegation, that's my understanding of why you were held no bond, is because there was an allegation of a new felony committed while on release. That's the basis of the no bond.
Presumption of it or whatever.
Right. So now, we don't have that pending, right? We don't have,
If
you enter the plea.
If I enter the plea.
right, yeah, so we're on the same page, great. So if you entered the plea, we wouldn't have that pending anymore. In fact, we would have probation available circumstances. I think under those circumstances, it is the right thing to consider what release conditions pending sentencing. Now, this is how I typically do that, so you know. Somebody enters a plea, similar to this, where probation becomes available when it was not available as charged, okay? So at that point, then I would normally turn to the state and ask the state for their position with regard to release pending sentencing. If it's a victim case, I ask the victim their position pending sentencing. I then ask counsel, in this case you directly, your position with regard to release pending sentencing. After all of that, I would consider whether to release or keep you detained pending sentencing. Sentencing has to occur within 30 days. I can't tell you what I would rule. I can't tell you what the state or the victim would ask. I can just tell you that that's the procedure I would use with regard to release. If I released you, you'd be released. We'd have a sentencing within 30 days in front of Judge Metcalf. If I didn't release you, you'd have a sentencing 30 days in front of Judge Metcalf. That's the procedure.
Right, and the procedure, I understand, we know the
Okay,
state.
just I wanted to make
I
sure.
know the state would say keep him in jail, but I feel like that's making a mockery of this whole thing. If I'm saying I'm willing to plead guilty, and you release me today, I'll go home and stop the harm. And they're saying, you know what, no, just keep him in jail. I feel like that undermines their whole case, truly, because,
There are different arguments on both sides, and I've seen
mean-
both made.
I mean, I'm highly likely, I'm a very low risk score, I'm highly likely to get probation. None of these prior things, I don't even have them because they're dismissed, this whole count one case consolidated with the other. all
That's
that.
kind of an argument for after, Mr. Myers, if you did enter the plea, I'm happy to hear your arguments with regard to release and the states as well
Well, I
as,
know their position, and to me,
but that's something I have to consider only if you enter this plea. If you don't enter this plea, I'm not.
oh, no, I know, I'm not asking you to rule on that now, I'm just.
And I want you to enter the plea
Oh, for sure,
because
no, I know.
I think it's the best for you, not for any other reason.
Well, I mean, it's when you take something like this, it's not just what's best for me, when they're hammering down your throat about the victim, I gotta take in consideration, if I'm not a heartless bastard, the victim and this kind of thing, so if it's okay.
It's nice to hear.
My videos are causing, they're saying that even when I make a phone call from jail, she gets calls. So my videos are up, people can watch them, people can contact her, people can, quote unquote, allegedly harass her. Well, I sit in jail charged for the crime. Other people are doing the exact same thing that I'm charged for every day. They're not charged. So what message does it truly send to victims everywhere, or to people that are watching the court right now, or 375 years of First Amendment, or to, I've never seen a case where somebody's been charged for criticizing the government in my life. I've just read 14 hours a day of case law. I know Barbara Lawal would never charge these charges. I know that under Pima County since 1976, there's never been somebody charged for criticizing the government.
So, Mr. Myers, I just need to know today, and I can give you another minute to check with
Yeah, I'm
Mr.
just trying to
Resnick.
figure this out because I don't want to make a mockery. The point of this is, we're making a mockery of this whole thing. If the victim is saying, your videos are harming me, but you can leave them up. We're making a mockery of this court every time I come to court. And so, do we want the circus to continue? I mean, the state has to work in this court, I don't. Okay, I only have to have one case here. The state brought this circus to town. The state wants this circus to be over in one hand, but they're undermining their own argument by saying, well, we'll offer you probation and you can go back to the community, but you can't go back to the community yet.
So, Mr. Myers, the state makes plea decisions for a couple of reasons, and you're right, the benefit they get is they get a conviction, they don't have to take you to trial, that's their benefit. Your benefit would be less prison sentence than you would get if convicted at trial. Everybody's got a benefit and a loss when they do a plea agreement of some kind.
But doesn't the victim come into this? It's not just the state and the defendant?
The victim had the right to be consulted about the plea agreement, the right to make any objections that she wishes to make to the plea agreement if she had any, and the right to be present. She gets that right.
This is not a victim, quote unquote, victimless crime. So there's a victim in this case, right?
Right, and she has the right to be present, the right to know about the plea, and the right to object to it.
I'm just trying to understand, okay, so the victim is being victimized allegedly. But they want to keep me in jail with the videos up and continue the victimization. That undermines the whole, I read a lot of case law over the weekend, and I haven't found a single case of a public employee being able to charge somebody with harassment.
And you're welcome to take it to trial, Mr. Myers,
Wow.
if you think you have a valid case, by all means. I mean, it's very important that you exercise your constitutional right to a trial if you think that's what's best for you, or you think that that's what's right. Knowing.
I mean, to me, reading the rule, we can stipulate to my release. And they won't.
Well, the state doesn't have to, though.
I'm not saying they do. I've already talked to them about it.
Yeah.
So I just don't really know, vacillating because.
I don't think you should enter this plea based on release or non-release.
Well, that's
Because
the only
the
reason
plea
I would do it, because, I'm only getting, trial's July 22nd.
Right.
I'm gonna go sit back at the jail for 30 days, give up all my rights to an appeal, stop litigating the case, not get my depositions, not force the victim to come under the scrutiny of the witness stand, not catch the detective under, he perjured himself at the grand jury. I'm giving up a lot of strong leverage too if I take this. And if it's just, well, you'll get less charges and still go to prison, well, that doesn't benefit me, because then I don't have the appeals. So I'm giving up. I would rather go to prison for more time and have all my appeals, because all my appeals say that I'm not guilty. All the case law says I'm not guilty. So if we were just deciding this on case law, this would already be dismissed. But you can't get into the facts, before trial.
Right, and you alone have to make this decision as to what's best for you, whether entering the plea or going to trial is. And you're right, you give up rights, the state gives up things as well at a trial, and you both get things out of plea. That's the way, to me, a plea agreement is like any other contract you enter. It may sound silly to compare it to a contract to build a house or something, but in reality, or to buy a car, in reality, in some ways, it is the same. You get a benefit, the car you're buying. the seller gets a benefit, the cash for the car. You do it for those reasons. The seller loses something, the car, you lose something, cash. So it makes it very simplistic, but a plea agreement really should have a benefit to both, and there's something you both give up. This, on paper alone, shows a benefit to the state to me and a benefit to you. That's just paper alone. That's not the basis behind the paper, like the arguments, legal arguments that you believe you have, Mr. Myers, and whether you think you can win this case either in trial or on appeal. That's a separate issue, but it is important that you consider the fact that you could get convicted in a lot more prison time. And Ms. Stiles, if I'm correct, if he's convicted at trial, there is some mandatory prison time, correct?
Yes,
Of
sir.
everything as charged.
So if he has prior convictions, they're old, but they would make it prison mandatory even if he's just convicted in one felony at trial. And then because of the separate dates, he faces the possibility of stacking and that they'd be then treated as a category 1 repetitive offender. And then on the second case, you would also have the on-release allegation, which would then increase. So yeah, well, no, it adds 2 years.
And that 2 years is flat, isn't it?
So, and that's,
Yeah, that's my, am I right, Mr. Resnick, that 2 years is flat? Okay.
Yeah, I'm aware of all that. I just don't see the benefit to the state. I mean, they gotta.
Well, so the benefit to the state is if
That they
you
get
enter
me
the plea,
convicted of
that,
something I didn't do.
well, if you didn't do it, sir, you can't enter a plea.
Well, I
So,
definitely didn't do it. I'm just entering the plea. The only reason I would enter the plea is because I haven't seen my parents in 5 years, and they have been planning to come to Tucson next week for 8 months anyways, which the state is aware of because they listen to all my calls and read all my messages. So I mean, the only
well, they'll be
benefit,
here then either way.
beware.
Whether you go to trial in July or whether.
No, I mean, they're coming to visit next week. They live in Michigan.
But I thought you said for 8 months.
No, we've been planning this
Oh,
for 8 months.
I apologize.
This is something that was in the works for 8 months, and now suddenly I'm in jail. They're driving across the country to visit me. My sisters are 70 years old. You know, the state is gonna argue against me being released today if I enter this plea. So to me, the benefit would be that I get to see my parents who I haven't seen in 3 years. You know, I get to go home and take the videos down and direct the attention. You know, then the videos would be, oh, look, the judge did the right thing, or the court did the right thing, and they let this guy out of the gulag because he should have never been there. But it doesn't seem like the state, I feel like the state is disingenuous. You know?
Your Honor.
Well, so, and yeah,
I think Mr. Myers is hoping that I'm gonna change my mind and agree to his release. I can tell you that will not happen at there, so he can keep talking about it and throwing that out there. It will not change. And I've stressed that to him. My belief is that he needs to be in custody until sentencing. He had his arraignment, on the first case, and that very weekend, he went and committed new felony offenses against his victim.
Allegedly.
so I understand it's alleged. I understand this is the state's argument.
And so, you know, I have concerns if he is not being supervised by probation. We made it probation available, but probation comes with a lot more conditions of release and a lot more monitoring than does pretrial services. In pretrial services, him being out before was not enough to stop him from doing this. And so if he's giving this speech right now, hoping that I'm going to change my position on that, I can tell you it's not going to happen. And if he would like to go to trial, we are ready and, you know, to go to trial, so he can make his choice. So if he wants the plea, it's available to him today. If he doesn't want the plea, we're able to go to trial.
Yeah, I don't think I was trying to get
Can
it
you
to
do
agree.
it? Hold on 1 second, Mr. Myers. Can you do a Donald record today? Have that information? It's okay if you can't, I just wanted
Yeah,
to.
I'm starting to write it out. It, you know, a little
Okay.
lengthier.
I know, I know it's a lot of math.
What is that?
Okay, so the Donald record, that's a case, and it basically says that, so if you accept a plea, I have to find that you knowingly,
No, I know.
intelligently, and voluntarily. If you reject a plea, I need to know that you knowingly, intelligently, and voluntarily rejected it. You can't knowingly or intelligently reject something you don't know what you face, for example. So if you have no idea what you face being convicted at trial, how are you knowingly rejecting the plea agreement? So I need to know what
I see what you're saying.
you're facing at trial, and I've not done the math, so I asked Ms. Stiles if she had.
what you're facing at trial, so I can ask you to compare what you're facing at trial with this, and if you wanna reject the plea, again, no problem. I'm just knowingly, intelligently, and voluntarily getting on the record that that's how you're rejecting it. Does that make sense, Mr.
Yeah,
Myers?
yes, and I don't think I'm not trying to get her to change her mind, because it's up to the court. It's not up to her
Right,
to release me.
and you know she's gonna argue that.
Of course, I already know that, that's why I don't even know why she's grandstanding, but the point is that I gotta consider the rest of my life, and felony convictions, I own businesses, employment, things like that, versus, sitting in jail a little bit. I'm gonna already be sitting in jail another 30 days if you don't release me, which I'm sure you'll just go with whatever the state says. And then, I could have just sat in jail a little bit longer and been found not guilty on all this and had a giant lawsuit against the city of Tucson, the police department, and all that. And, giving up all my appeals. It's just, I just don't understand how this plea bargain benefits the victim.
Well, it doesn't have to benefit the victim.
Well, the victim's not even being harmed.
But the victim, so Mr. Myers, the victim has to be aware of the plea agreement and has the right to object to the plea agreement. The state can offer a plea agreement regardless of how the victim feels about it. So if the victim doesn't like the plea agreement, and I've had victims not like the plea agreement both ways. It's too harsh, it's too easy, I've had both from victims. So the victim has that right, but the victim doesn't control whether the plea offer is made. That's actually controlled by the state.
Can I have one moment?
Sure. That makes sense?
Can I have 1 second, please?
Sure.
I can't hear you.
My understanding, just so you know, Mr. Resnick, is our mute buttons aren't working real well, so you might want to move the microphone if you didn't say anything. Sure. Do you want this on the record? anybody needs to stand and stretch or want to, I will give them a minute.
All right, Connor. Or me, should I?
Yeah, oh, yeah, sorry, I just got the email, right, so now my attention's on you.
You good?
Yes.
All right.
So just so we're formal, we're going back on the record, so, and I know you got a chance to talk to your advisory council. What would you like to do at this time?
We go for it.
You wanna do the plea? Okay, if you wanna do the plea, I need you to sign it. Does he have an original one?
This is the one that doesn't have the. I got it.
Oh, you've got it, okay,
I brought the, I just need to sign this here.
okay, and then,
Your Honor, the victim does want to be heard at some point.
okay. Do you wanna be heard before, ma'am, or after?
Do you want to be heard before she goes through all of it, or do you want to be heard before she just accepts?
If you have any objection, I'd rather hear you before, but if you
if it's something else, then I can hear you after, whatever's good with you.
It's not really an objection, more consideration.
Okay.
So I'm looking either way.
Thanks.
Wait a second, no, let's wait to hear this. I want to hear what the plea is.
So she speaks before we do this?
I can do it either way. Would you be more comfortable if we heard her from her first?
The name, but no one's recording it. The internet, no.
Yeah.
Whatever makes her feel best.
So you want to go, let me know your concerns or what you would like me to consider here. And it's Ms. Walker, correct?
Yes,
Okay.
yes. Your Honor, thank you for the opportunity to speak. While I understand that specific sentencing details, including any prison time and probation conditions, will be determined at a later stage, I feel compelled to make my position now, as these conditions are critical to my standard of a proposed plea. I appreciate that Mr. Myers appears prepared to plead guilty to two of the many crimes he has committed against me. In doing so, he is acknowledging that his conduct is not protected speech. It was a sustained and calculated pattern of stalking and harassment that caused serious harm. These were not isolated or impulsive actions. They were intentional, repeated, and profoundly damaging. However, while I do support this plea agreement, I have serious reservations. Mr. Myers has shown time and again that he is unwilling to follow court orders. Based on his behavior, I do not believe that he's capable of complying with probation without strict and ongoing oversight, along with serious consequences if those terms are violated. Any plea Mr. Myers enters should ultimately be accompanied by a period of incarceration, which I understand will be determined by Judge Metcalf, as well as strong enforceable probation conditions that are specifically designed to protect me, my family, and the community. These measures are necessary, not only to reflect the seriousness of Mr. Myers' crimes, but to ensure that I and those close to me can move forward in safety. When the court considers sentencing, I will be prepared to request conditions that provide meaningful protection. In the meantime, I respectfully ask the court to take this into account as the case proceeds. Thank you.
Thank you very much. Mr. Myers, are you still ready to go through with the plea? If so, I just need the signed copy and I can leave.
That was some, serious,
If you're ready, if you sign the plea, then I'll make sure Ms. Stiles signs the plea, because my understanding is she has not either, and I need her signature as well. And then I would go through the questions with you.
oh man, that was.
I just need the signed copy whenever you're ready, and then, and I, as I mentioned, I also need that from Ms. Stiles.
You still gotta go through that.
Oh, I gotta ask you a lot of questions, yeah.
Oh, yeah.
We're not done.
Yeah, the way I-
There's, Mr. Myers, I have a series of questions to
Oh, yeah.
ask you.
Wanted to make sure we weren't skipping that.
Oh, no.
Oh, no. If at any time you don't understand my questions, you need to let me know. Anytime you wish to speak to your advisory council, you're welcome to do so. Just let me know so I make sure you can do that respectfully. Sometimes I talk fast, so if I get going and you feel like you're missing something, let me know.
They say I do too.
All right. Can you state your full name for me, please?
Lane Myers.
And you,
You want to know that?
sure. It's
Lane
on.
Jeffrey Myers.
And do you read and understand English?
Yes.
I have to ask everybody all these questions, so just bear with me. Have you had any alcohol, drugs, or medication in the last 24 hours?
No, definitely. In the last 24 years.
I need to let you know if you're not a U.S. citizen, entering a plea agreement can affect immigration status, resulting in you being deported or removed, preventing you from obtaining U.S. citizenship or legal status, even if later these charges are dismissed. Do you understand that?
Is there a way to stipulate deportation as part of this agreement?
Well, and I can tell you, if you're not a U.S. citizen, it can affect immigration status. That's all I can tell you, and I need to make sure you understand that.
No, I'm a U.S. citizen. I just want to know if I can.
I think, well, other than being on probation, I think you're always free to leave the country. Probation may inhibit that if you're on probation.
If the First
All right.
Amendment doesn't apply to anyone, I want to know.
According to the plea agreement under CR 2025-1060, you're admitting to amended count 14, stopping, oh, I did want to hold on. Make sure I got my stuff correctly here. And that would be a class 5 felony. And then on CR 2025-1454 to amend it count 1, aggravated harassment with a court order in place, a class 6 felony. On the class 5 felony, you face a possible prison sentence between 6 months to 2.5 years. And on the class 6, between a third of a year to up to 2 years. Any prison sentence, you would have to serve at least 85% of before you could be released, and 1 day for every 7 days served in what we call community supervision after your release. Probation is available on both cases and both charges. On both the class 5 and the class 6, probation can be for up to 3 years. It can also include up to 12 months in the Pima County Jail. There's a potential fine of $150,000 plus surcharges. And as to the special terms in CR 2025-1060, the parties agree that at the time of sentencing, pursuant to ARS 13719A, you shall be served with an injunction that prohibits you from contacting the victim. The injunction does not expire and is valid for the next 5 years unless it is issued pursuant to ARS 13719. Without any restitution, you could the victim for any restitution loss, so that would be loss. You are also giving up your right to a direct appeal, but you could challenge this with petition for post-conviction relief. Do you understand all those possible consequences?
Yes, ma'am.
Did anybody make any threats to you or promise you anything we didn't discuss here in court today that you consider this case? What we talked about before. Because I did talk to you about procedures we were
Yeah, no, I know.
But other than that, did anybody talk to you or promise you anything to get you entered this plea or make you any threats to make you enter?
My wife.
Okay, well,
I'm just kidding. I'm just kidding.
all right, so you don't feel threatened or coerced to take the plea, is that correct, Mr. Myers?
No, I'm doing this.
Okay,
I know. I got a plan.
all right. And did you sign this plea agreement?
Yes, ma'am.
And you signed that after we talked about things here today and after you had the chance to speak to your advisory council, correct?
Yes.
And do you feel that it's in your best interest to enter this plea, given all of the circumstances and surrounding consequences that you potentially face?
I'm taking my advisory council's advice.
Okay. And so going on to amended count 14, It refers to September 12th, 2024 through approximately, and this is on or about, so it doesn't have to be the exact dates, but on or about September 12th, 2024 through February 22nd, 2025. Did you intentionally or knowingly engage in a course of conduct directed towards Shannon Walker which caused her to reasonably feel for her safety and or the safety of her family?
The state can lay the factual basis.
I'm not going to lay the factual basis, he's gonna need to lay it.
So was it emails, phone calls, things like that, Mr. Myers, that you called or sent to Ms. Walker?
That's up to the state to lay the fact in the court to find.
Sir, I need some facts from you. I'm trying to give you some pointers. Mr.
You want the
Resnick,
facts from me?
let me see, Mr. Resnick might have something that I can follow up.
Hold on,
If you want
one
me to lay the facts, I'm
Shocking distress / fear under count 1,
well, the allegation is on, like you said.
count 14, excuse me.
You're talking about the first one, 1060. So
Yes, sir.
it's saying through September 12th through 2024, 12th through September 22nd. So the factual basis is that on June 4th, I was arrested for booing at the city council meeting. Matthew Walker started prosecuting me. I began investigating him. I determined that his wife was a government employee for the state of Arizona who worked at the law school and worked with Matt Walker in on special projects between the two entities. At that point, I then made a YouTube video saying, I made a phone call to Ms. Walker and I advised her that her husband was violating the law and she had an oath and I called him a crooked ass prosecutor. And so then in retaliation, she went and had my wife, her and Stacy Jane had my wife fired from her job. So then at that point, I made a video explaining what happened about her role in that. And then I made a video which showed her government information on a government website. And at that point, she went and retaliated by coming to this court and getting an ex parte injunction against harassment by lying to Judge Walton.
Okay, well the harassment is after.
No, she got an injunction for harassment.
Okay.
By lying to Judge Walton, Judge Weiland, and then the next day she came dismiss that injunction for harassment unlawfully issued again by Judge Walton after saying if you dismiss it, you're not eligible to get another one. She was then granted another one without testifying to any facts or acts contained in the petition. I was unaware of that, so I was served the injunction, and then once I was served the injunction, I made a YouTube video showing a publicly available public court document which contained public information about a government employee. At that point, I then had a hearing with Judge Griffin in which he said all my videos that were previously posted are allowed to remain posted because it's my First Amendment right to have those videos up. He would not be ordering them taken down, so I left those videos up and I moved on from November to January when a judge in this court made me aware of the hearing that supposedly disappeared on October 9th. When I became aware of that hearing, I paid Tracy Robinson $35 for the record from the court reporters. I then posted that hearing on my YouTube channel, letting the whole world know how Shannon Walker committed perjury 33 times in 9 minutes with Judge Weiland. Went back the next day and somehow issued an injunction based on one alleged act, and then was told that the hearing will be sealed unlawfully. I thought that was newsworthy, so I made a video, I posted that. At that time, I had an injunction which unlawfully restricted my ability to disseminate information about government employees. I knew that it was unlawful and I was appealing it, so I went ahead and made the video anyway. I exercised my First Amendment right to disseminate information about government employees, and that was a 4-part series. I made 4 videos about her lies in court, her Judge Walton's issuance of the injunction despite her stating in the hearing that if it was dismissed she would be unable to do it. She did it anyways. I thought that was newsworthy. I own a news media company in the state of Arizona, so I thought my freedom of press would outweigh the injunction. I then posted that and then moved on with life on February 22nd. On March 7th, they indicted me using the detectives lied to the grand jury, got an indictment, and then I was served that indictment on March 12th. I came to court on March 14th and was arraigned on that charge.
So, Mr. Myers, I heard you say that you made some calls.
I made one call.
A call to Ms. Walker. You did 4
Prior to the injunction.
Right, that would be within the September 12th, 2024 through February 22nd.
Yeah, I called and left their voicemail saying that Matt Walker was a crooked ass prosecutor.
And then there were 4 videos that you posted.
Containing the FTR that I paid $35 for from the court reporter.
And so you posted some things that sounds like you knowingly engaged in a course of conduct toward Ms. Walker. What I want to know is you also reporting to this, which would cause Ms. Walker to reasonably fear for her safety or the safety of the family. So with regard.
There was no threats.
So there can be direct threats, which are pretty obvious, and then there can be things that just make you
I thought there was
feel
only true threats.
uncomfortable.
And Your Honor, I can supplement a little bit.
No, she said she wasn't saying nothing. She wasn't saying nothing.
Then, sir, I'm gonna reject the plea, because I don't have facts right now. I need to know.
Those are the facts.
So let me
Those are
hear
the
what,
facts.
let me hear what Ms. Stiles has to say.
Your Honor, he engaged in posting Ms. Walker's information regarding her work email, her work address, her work phone number, and then he would put it onto his YouTube page, and then he put it up there, and he would encourage his followers to contact her, in which they did, and they left her harassing messages that also ranged from things like wanting her to be raped and killed. And so these messages kept coming in. He was made aware of these messages. He's indicated numerous times that he was aware that his followers were reading these type of messages, and yet he continued to put up her information during this time and causing those followers to continue that contact with her. So he had initial contacts with her where he left her that message. He went to the law school looking for her, but then he also would use his social media to encourage his followers to continue that contact.
Do you understand that all of that would have made her fear for her safety,
No, I
Mr.
don't.
Myers? Then do you have any other reason why she would fear for her safety?
Because she doesn't understand that she's took an oath under ARS 231.
Taking an oath doesn't mean you have a right to be harassed,
I didn't harass her.
great fear.
The allegation other people did, not me.
So, but sir, if you're promoting them and
I didn't
encouraging.
promote anybody and I didn't encourage them. There's no factual basis for me encouraging them.
Thank you, Mr. Meyer. At this point, I can't take your plea because I have a factual basis, and part of that is that Shannon Walker to reasonably feel for her safety or the safety of her family. And if you can't, and I'm fine with that if you can't do it, so you know.
But I'm just curious if you're asking me to admit to that because the state even just said that other people called it.
And that you were aware and you continue to post her address and information, and you continue to encourage people.
They posted her address. So I'm confused because I let the state, I said the state could do it, and they refused to do it, and now they're disputing what I did.
Mr. Resnick?
I guess the issue is, Judge, what Mr. Myers did was he posted publicly available or publicly facing information that's on the UOP's website. So obviously he has no control of the third parties. He can't stop them from doing whatever.
And I also didn't encourage them, that's a lie.
And yeah, I mean, again, if I cover a news story, if I were a news organization and I cover a news story, we deal with it all the time. You know, you may wind up getting phone calls and comments and things from third parties who see the news story, but it's not like Kagan or TV13 have any control over that. And so they would want to be held liable or charged with, you know, harassing.
Then I don't have a basis.
No, I agree, and that's part of the First Amendment title.
Yeah.
I mean, you're allowed to use the record, you're allowed to use the grand jury transcript, and if you read the grand jury transcript.
Sure, I won't. First of all, I don't have it in front of me. It gets sealed. I can't even pull it up on Agave.
Oh, I thought that the rule was that you could use anything
I
on the record.
I can pull it up and all that, but even if I do that, I have to have you agree.
That what?
And all the facts that are in there are accurate.
In the grand jury testimony.
And yours already told me you
Hold
don't
on,
agree with
You're
that.
saying, agree. Well, what the grand jury says and what Rachel Stiles just said are two different things.
What I have to have you say to me, Mr. Myers, is that on or about September 12th, 2024 through February 22nd, 2025, you knowingly engaged in a course of conduct. I think I have that because I think I have emails that you've agreed that you've, or a phone call you've agreed you've made and multiple postings for videos. So I can take that as a course of conduct. So I've got that part of it, which would cause Shannon Walker to reasonably fear for her safety or the safety of her family. I have to have
That's
something.
subjective though.
Well, I have to know that you agree that what you did made it reasonable for her to fear for her safety or the safety of her family, and I don't have that right now, and I'm okay not having it. I'm not asking you to give me something you can't say, but if it's reasonable for her to fear based upon these phone calls and the things that she was getting, that you initiated by putting her information out there, it may have been a public-facing website, but you put it out there in a different way. If you would agree that that reasonably resulted in her having a fear for her safety, then I can move forward to the second one.
You're asking me to admit to allegations that are not made against me.
And I'm just fine if that's how you're doing it.
You're saying
Mr.
that you
Myers.
want me to say that I believe Shannon Walker, it was reasonable for her safety based on my conduct. But the state just offered evidence of other people's conduct saying they would do this or that. I never said I would do this or that, and I never encouraged people to do that.
So, Mr. Myers, so the same thing happens to me again taking a drug plea. It's charged for sale, the plea is for sale, they can admit they possessed it, but they deny that they did it for sale. I cannot accept that plea. It may be a crime to possess a drug, but a plea agreement I have is possession for sale. I have to have both count. I have to have the drug and I have to have the sale. In this case, I have to have the conduct, which I'm comfortable with, and then I have to have, which would cause Walker to reasonably feel for her safety or the safety of the family. I have to have that. So if you can't acknowledge that your conduct would reasonably result in that, I'm okay with that, but it just means I can't take the plea because I have to have both factors.
So my question is where is that stem from? Because the rule says that the court needs to find the facts, not that I need to admit to them.
Well, I need to have a factual basis, and
Right,
I
so
get
the
that
state-
from
The
individuals.
state could do it.
And then I asked you to agree to it, and you didn't agree to what they said.
Because the rule doesn't say that I'm required to admit anything.
So, sir, I will not take a
So that's a
plea.
personal, that's your personal,
That's the way,
interpretation of.
my view of the law is that the defendant has to enter a factual basis and enter a plea. And they need to do so knowingly, intelligently, and voluntarily.
Is that
so they
your
either
version
have
of
to-
Rule 17?
That's my view of law. I will not take a plea just because the state rattles off a bunch of stuff and have a defendant sit there quiet. Every plea I've ever taken on 9 years on the criminal bench included a factual basis that somebody provided and that the defendant agreed to. If you cannot agree, no problem whatsoever. I just won't take the plea, sir. I have to know you agree to the factual basis. If not, I will not accept it.
So
And you're welcome to try Judge Metcalf. I don't think he'll accept it either, but
well, you're saying that, when you said the law or whatever, that you're saying you need it based on the law. Are you saying based on Rule 17? Because the way I read Rule 17 in the case law is that the judge is required to make that finding based on the record, not on me admitting it.
I can look at facts from the record and then I can look at you and say, do you agree with those facts? And if you agree, that's fine. I will
Well,
not
if
take
you looked at
the
the record
plea.
into that, I would be more comfortable than with the state, just like you said, just rattling off some stuff and then saying, do I agree? Because
So
what she
with the-
rattled off is not what I'm
With
trying.
with what you did, the course and conduct of the posting of the videos, the phone call, with that, was it reasonable for Ms. Walker to fear for her safety or the safety of her family? Was that
I
reasonable?
don't think that she should have been fearing for her safety.
Okay, then I don't have a factual basis. So, and which is fine, again, no problem. I am gonna make sure that, Michelle, can I have you?
Your Honor, I have a Donald record because after this, we're gonna pull the plea. So
Okay.
we're gonna be done, we're just gonna go to trial.
Then let me hold on to this for one more
So
minute.
if you can't agree that him posting those videos caused those people to reach out to her and that they wouldn't have reached out to her but for him doing that, then
I think they reached out based on her lies in court.
So I think we don't have it.
So it sounds like we won't get there, so we're just gonna plan on going to trial, so let's just go ahead and do the Donald,
Sure.
and we're gonna pull the plea after today. We're
Please,
just gonna-
please listen to Ms. Stiles. Mr. Myers, I'm gonna ask you some questions when she gives us this information. Go ahead, Ms. Stiles.
So, Your Honor, I'm gonna go through, I'm breaking them up, they'll be consolidated for trial purposes, but I'm breaking them up into segments just so that on release allegation gets the 2 years extra. So, in first matter, he would have the class 6 felony that would carry, all of this has been mandatory because he does have prior felony convictions. And, Your Honor, he's not paying attention, so.
Mr. Myers, make sure you're listening. Okay, the class 6, I'll go through it.
What is that we're doing here now?
We're getting a Donald record to make sure that you understand.
I thought you said that when you were rejecting the plea.
I am, that's why we have to do a Donald record.
Oh, okay.
Go ahead.
So for the class 6 at trial, he's facing the 0.33 years up to 2 years. For class 5 at trial, he's got 5 of the class 5, so each one carries a range of 6 months up to 2.5 years. And then on the class 3, for the first case, he'd face a range of 2 to 8.75 years. Again, these are all prison mandatory, and
They could technically be stacked, correct, because they're different dates?
correct. And then under the second case, we would have, it's increasing the range because of the fact that we have the on-release allegation. We have 2 of those class 5s, each of them carrying a range then of maybe 2.5 up to 4.5 years, with that added 2 years. And then with the class 3 offense, we would then be dealing with 1 on release, so then it's a range of 4 to 10.75 years. So at trial, he would be facing a minimum, if he's convicted of everything, of 4 years up to 43 years in prison.
All right, so Mr. Myers, did you hear all that?
Yeah, do I get to, add up how much money and damages they're gonna pay me if I'm acquitted?
Sir, that's not what we're doing on a Donald record. So on the Donald record, I need to make sure you understand that at trial, you're convicted as charged. So it has to be, this is with everything. The minimum you face would be 4 years in the Department of Corrections, and the maximum would be 43 years. And that's because they can take the first class 6 and sentence you to 2 years on the maximum level, 2, and then there's 5 class 5, so they can each be 2.5.
Actually, those class 5s are only class 6s.
Okay,
They
well,
mistakenly
that-
labeled them as a class 6. I have.
That would be a different argument at trial. I'm saying
Well,
the
you said
way
you gotta
it's
make a
charged.
correct record, right? You gotta
I-
make a,
So,
so it
Mr.
has to
Myers,
be true that,
as it's charged, and as it's charged as a 5.
Oh, I see
So
what you're saying.
there may be a different argument later. There may not even be all these convictions. So I'm just saying, you worst case scenario, you get convicted of everything as charged, okay? Okay, so as, worst case scenario, as charged, you face between 4 to 43 years because of the stacking, okay? Worst case, all right? The plea agreement and probation's not available. Even if the judge wanted to give you probation, doesn't matter, the judge doesn't have a choice as charged, okay? If, with the plea agreement, probation is available, so that's the first big difference. Because probation is not available as charged, it is available under the plea. Under the, as charged, you face between 4 to 43. Under the agreement, you face between 6 months to 2.5 on one, and a third of a year to 2 years on the other. So worst case scenario, running them consecutive, you face between 6 months to 4.5 years. Is something big over here?
okay. So I just wanna clarify that,
Sure.
the maximum on the plea bargain is more than the minimum on the thing you just calculated.
Correct. So the maximum under the plea agreement, which would mean that the judge had to aggravate it, would be 2.5 years on the class 5 with the consecutive 2 years. So this is what under the law judges have to do. You start at the presumptive. So on the class 5, the lowest is 6 months, the presumptive is 1.5 years, and the highest is 2.5. When a judge looks, and if you look at the statutes under sentencing law, a judge has to give mitigating factors to go down from the presumptive and aggravating factors to go up.
So you're right. Under the plea agreement, the 2.5 to 4 years is 4.5 years is more than the minimum you could face if you went to trial. To get to that 4 at trial, if you were convicted of everything, the judge would have to substantially mitigate all of those charges, which is unusual in a case where you have 2 different cases to run both of them all concurrent and together.
You already said
It's just
you rejected the
unusual.
plea, right?
Yeah, I just want to make sure you understand, because that's what's important.
Even if I agree or not, you said you rejected the plea.
I will reject the plea if you cannot give me a factual basis. If you want to go back and try again, I'm willing to listen. I just need to make sure
Here's
that,
the delineation between my factual basis and you accepting it.
so I can only accept a plea if knowingly, intelligently, and voluntarily enter it. I can only accept a plea for that. To knowingly, you've got to know what you face. You got to understand the conditions of the plea. You also have to give me a factual basis about it. I need to know you're pleading guilty to these charges. If you're willing to do that, I will take the plea. If you're not willing to do it, I cannot take the plea.
Can we use the statutory definition of knowingly under ARS 105.9?
So, sir, I'm not going to take this plea. I can't make it any more simple than this unless you agree to me that based upon your course and conduct, Ms. Walker was reasonable to fear for her safety or the safety of her family. If you can tell me that based on your course and conduct, that which would cause Ms. Walker to reasonably fear, I can take the plea on that count. I still gotten to the other one, but I need to know that it was reasonable based upon the way this is charged,
Reasonable for her to fear for her safety.
or the safety of her family. It has or.
You're asking me for my subjective, you know what I mean?
I'm asking you to agree that the course and conduct you did would make it reasonable for her to fear for her safety or the safety of her family.
And Judge, I apologize.
That's okay.
I'm really not trying to muck this up, but I think what we're caught up on is what the court's asking, and probably the problem statutorily with this statute, is it requires the defendant to put himself in the place of the victim. And whether or not it's reasonable for her to fear for her safety or the safety of her family is up to her. Right? Anybody who actually has that fear feels it's reasonable. I mean, nobody's gonna run around and say it's unreasonable.
She's certainly entitled to feel how she feels, but
Right, and I understand how what both of you are saying. I just think under the law, there's many times where we use reasonable. Is it reasonably that when you do X, Y, Z, this would happen? Is it reasonable that by putting out her address, her phone number, her information, and I understand, Mr. Myers, that they're on a separate public website, but by doing it with regard to the other statements that you made, is it reasonable to believe that that would then result in her having a fear for her safety or the safety of her family?
so are you already saying that
The jury will have to determine that reasonableness too. So
are you saying that are you just skipping the intentionally or knowingly, or are you saying you find that?
So you have to knowingly engage in a course of conduct. I'm okay finding that because
You have to knowingly engage in conduct that would make her fear for her safety, not just
That's-
engage in conduct.
right. So, but what I'm trying to make it so you understand where I'm hung up.
Because I read the ARS, because, you know, this legal jargon is the technical nomenclature of the law. The law gives you the definition of knowingly, not Lane Myers or Shannon Walker or
So
Richard
sir,
Biles.
I need to know that you agree that it was reasonable based on your knowing conduct of putting her address, phone number, information out there online, that you knowingly doing that conduct, and by calling her, would reasonably result in her fear for herself or for her family. If you can say that, we can move forward. If you can't, again, no problem. We will not go forward.
Judge, would the court accept that we acknowledge that she did fear for her safety and that of her family, and that her fear was reasonable, and that she believed her fear was reasonable? We have no argument about that. It's just that he can't put himself in her shoes to know what she thought reasonable was, but we'll agree that she did.
Your Honor, I pulled up the Raji just to see how it kind of breaks. Is, for,
That's a jury instruction, just so you know, Mr. Myers.
Yeah, the instruction,
We always call them Rajis, I just didn't know if you knew that, sorry.
so, the crime, so it says the crime of stalking requires proof that the defendant, one, knowingly or intentionally engaged in a course of conduct that was directed toward another person.
And I'm okay, I feel like I've got that.
And then it says, and that conduct caused the victim to reasonably fear for, and then that's where we get to the safety.
isn't that up to her to determine though?
Okay, so do you agree with me that you engaged in a course of conduct that was directed at Ms. Walker, that being the phone call and the 4 videos?
The phone call only.
Well, why do you put videos up? That was not directed towards her?
Absolutely not. Those are not directed at Shannon Walker. I didn't tag.
And I don't have a course of conduct, 1 phone call is not enough.
The
So
the directed at means that I would say, hey Shannon, or I would tag her in social media, or is a Cake on 9 story directed at the person in the video?
Absolutely. So, I'm going to find that there's no factual basis for the plea agreement. I'm gonna find that the court has gone through the Donald record and that Mr. Myers is knowingly, intelligently, and voluntarily rejecting the plea because he's unable to provide a factual basis. I'm going to affirm the next court date, which I believe is just the trial. Just wanted to make, oh wait, there's a status conference, right, on, July 14th at 9 o'clock.
Are you also allowed to make orders in this case? That to order them, because they've been telling me that I was gonna get the pre-trial witnesses for 2 months.
That's,
Just
that's,
try to order them.
that's a separate order for Judge Metcalf, so no on that one. Okay. All right, but the parties should be prepared to proceed to trial. Thank you, everybody. Thank you for everybody's patience.
Mr. Rogers, do you want to go ahead and take that? Just because I don't want to have any data signatures that. Just
Hey, can you get my name?
don't want to have that.
That's that bootleg chick.
What's that?
That's that bootlegger chick with that show channel.
Which one?
That old lady with the white hair.
She's a bootlicker?
Yeah,
Oh, with the
remember
bootlicker channel.
Remember I told you she was.
What's going on? The other door, it says.
Yeah, I saw one that was talking all kinds of, saying all kinds of stuff, and she wasn't even making no sense. But like talking shit on us, like we were idiots. Names of the judges right here.
What's that?
Their statements. I really don't think so.
Where's the elevator?
You recommend it? That's what we're doing? Situation change. Oh yeah. Here we go, YouTube. 45 to life. No faggots in this elevator. Wrong one, brother, wrong one.
Oh,